Now let's look at some of the uh, types of crime. We have the most serious crimes, the categories of crime. The most serious are felonies, and they carry the strictest sentences, of course. The next are misdemeanors, which are also serious, and it goes by the length of time. A misdemeanor might be up to 7 years in jail, for example. The least serious, but they're still crimes, are summary offenses. That could be a disorderly conduct, it could be a traffic citation, and so on. And why it's important to this class is that you know that the magistrates that we talked about in that triangle that I showed you last week, the district justices, the neighborhood judges, they can find someone guilty or not guilty of a summary offense, of the least serious crimes. So if you go to traffic court, you can be found guilty of a vehicle violation or not guilty. However, in felonies and misdemeanors, the district justice can only decide, is there enough evidence to go to court? And if they decide yes, now it goes to the next court, the Court of Common Pleas. If they decide the Commonwealth did not prove there was enough evidence to justify going to court, then the case would be dismissed, but it could still be refiled. There's no double jeopardy here. So the magistrates, the district justices, they are the first place people go to in a criminal case. And I want to just finish this particular lecture with the standard of proof. In a criminal trial, the standard of proof is beyond a reasonable doubt, as I said. At the magistrate's level, when the magistrate is trying to decide if the felony or the misdemeanor has enough evidence to go to court, it's called prima facie, P-R-I-M-A-F-I-C-I-E. And what that just means, was there a crime committed and did the defendant probably do it? So at the preliminary hearing, which is what I'm talking about, where the magistrate decides if they want to send a case to court or not, the standard of proof then is, was a crime committed and did the defendant probably do it? The Commonwealth has to prove beyond a reasonable doubt once they get to trial. So I'm going to email you just some things to look at in chapters 1 or 2, but some of the things I just went over are not in those chapters, so it is very important that you take notes and that you remember them.